enterprise fund.
Mr. Mubhan, on that score, the removal at will argument that the government makes hinges a lot on the assumption that the removal power comes with the appointment power, and that because the Secretary has the power to appoint, he therefore has the power to remove. The Fifth Circuit didn't address the antecedent question whether the Secretary indeed has the power to appoint. What do we do about that? Should we remand the case to assess that in the first instance? Just as Justice Thomas's questions point out, there seems to be some reason to question that.
Well, so I guess what I would say is the following. There is certainly no removal restriction in the statute. So whoever it is who has the ability to...
Whoever it is an important question, though, right?
So I take the point, Your Honor, but in terms of the question of is there a removal, at-will removal, there is at-will removal.
I understand that, but you say the Secretary has that at-will removal power. That's a pretty critical premise of your argument, and it's an untested premise, one that the Fifth Circuit hasn't addressed.
So,
and is being really addressed here for the first time, as you point out, and therefore, would you object to a remand for that consideration of that question?
Well, we think it is fully briefed here, and we think the court is capable of deciding.
Well, you also cite Cutter and tell us, we're not normally a court, reminding us, as if we need it, that we're a court of review, not first view.
So I won't object if this court doesn't want to address that question, but we do think the answer is quite clear for the reasons with my colleague, Justice Thomas. I don't think the statute could plausibly be construed to vest the appointment in the president and confirm.
I agree with that, but whether it vests it in the director as opposed to the Secretary is an interesting question.
Well, but that's a very easy question, because if you agree with me, it's at least in the director. The Reorganization Act...
I understand you think it's easy. Counsel always thinks it's easy. But I'm pretty sure Mr. Mitchell doesn't think it's quite... He probably thinks it's easy, too, just the other way.
Well, to be fair...
And no court's passed on the question. And so, again, I ask you, do you have any objection if we were to remand it?
We don't, but to be fair, I don't even hear Mr. Mitchell to disagree with what I'm about to say, which is that the Reorganization Act of 1966 clearly vests the Secretary with all the powers of the director.